A very good afternoon to all of you. We will be sharing a discussion on live-in relationship, the law, and the judicial perception. Live-in relationship is a concept which we may consider has evolved today, but in fact, it is something which has been traditionally in practice over a long period of time, since we all have seen or heard about the Gandhar Vivahs, which were being in practice traditionally in the Indian society. And these relationships involved no marriage, no performance of the necessary ceremonies. It was just a consensus or a willing relationship between the parties without the performance of the rituals. So living relationship actually has evolved from that conceptualization. And today we consider that it is something which has evolved from the Western ideology, but practically it was very much present even within our historical past or framework. Even historical scriptures and texts, they do discuss and talk about it, as this was in the Vedic era, and it continued even during the Muslim era. However, the British, since they brought in the laws, the codified rules and regulations, this got subdued even though it was still in practice. Now, India does not have a very defined specific legislation on law on living relationship. We are taking the help under Article 21, the framework to the Constitution, which says right to life and personal liberty. Whenever we feel that the individual has a right and he chooses to enjoy his life, live his life according to his liking, and if his right to privacy is being encroached upon, Article 21 is a good defense and an option which is available to the individual to move an application and seek a relief for themselves, so that the society can stop interfering in their life or in their discourse. So live-in relationships have been interpreted under the Constitution under Article 21 and Article 19 to the Constitution, emphasizing that it is an inalienable fundamental right and each one have a right to enjoy their privacy. Lately, after having constituted the Protection of Women from Domestic Violence Act, we can analyze that the law laid down a word which says relationship in the nature of a marriage under Section 2F of the Domestic Violence Act of 2005. So here it was an attempt to bring in relationship other than the defined relationship of marriage, which we under the Hindu Marriage Act constitute it as a sacramental union. So in order to bring in that other woman, the other man in the purview, this word has been used, which says under the Domestic Violence Act, that is the domestic relationship. And then to ensure benefits, time and again, the judiciary has been emphasizing and evolving that how various laws can be aided to ensure that Article 21 freedom and enjoyment of life and personal liberty is made accessible to the person who is approaching the court of law and seeking a relief from it. Now, there are three primary forms of live-in relationships in India. They are first, that is the domestic relationship or domestic cohabitation, which is going on between the heterosexual individuals. Secondly, it is the adulterous live-in relationships, which are also there in the society. And thirdly, the domestic relationship between the same-sex partners, which after the Navdeep Singh Johar's judgment has also gained primarily recognition and identification. Earlier also, people of same sex, they were lesbians, transgenders, they were maintaining these kind of live-in relationships, but society was not talking about them, discussing about them openly. But Navteej Singh brought the debate on the front. And now there is again a very strong demand which is coming forward under Article 21, right to privacy, that if they have a right to a live-in relationship, they should also be conferred with the right to marry if they choose to marry. So the debate is still going on, and added to it, the right to have children, which is adding another legality into the chapter, that whether if parties intend to be in a live-in relationship and society is recognizing it without the conferration of marriage, or those who want to marry, can the same-sex couples enter into a marriage? And third, can they have the right to have children under the domain of Article 21 to the Constitution? So these are the three major forms of live-in relationships which have emerged in the society. Now, if I look at the core issue or the mood questions that emerge of the conceptualization of the live-in relationship, primarily we are concerned with, is the Indian culture ready and willing to accept live-in relationships under its new connotations or the changing transformations that are taking place in the society? Are we enlightened and literal enough to understand this new terminology and this new form of relationship? Secondly, what are the consequences of adopting or refusing to adopt such relationship? Would they be for the growth and prosperity of the society? Or there is a traditional view which says it amounts to contamination of the society. It amounts to contaminating the pedigree table of the society, the right of the legal heirs or the right to succession. Who would succeed? The legally wedded wife's son or the person in a living relationship in the nature of a marriage over a very, very long period of time. There have been people who are living in relationship for 20 years without entering into a formal marriage. So here, this is another issue which has emerged out of this thought of live-in relationship. Then should a new legislation should be enacted in India to govern such kind of living relationship? Then what can be the implications of legalizing such relationship? Because it may look very easy, but as we open up the or unfold the layers, there are so many complications which are arising to determine what the court decided when it first opened up the doors way back in 1978 to say that long cohabitation can be identified as a live-in relationship equivalent or in the nature of a marriage, to today in 2024, how the society has evolved, changed, modified, and how they are adapting to these new terminologies, how new relationships have evolved and emerged in the society, and how far the Indian judiciary is playing a role in this progressive growth and development and defining these new relationships to address them within the framework of law. Now, I'll first focus on the major laws and then we will move on to the judicial aspect. Now, the one I already talked about was the protection of women from domestic violence act. Section 2F of the act is defining the term in the nature of a marriage between two people who are residing in the shared household. So a domestic relationship is defined, one, as a relationship between the parties or the two individuals who are resided together in a shared household or at any point of time have lived together or are connected to one another by consanguinity, by marriage, or they are, or by adoption, and they are friends or family, or they are living in the family group. So all these people have been categorized together to include that the other woman, the other man, who are not legally wedded can also be brought within the definition of the term domestic relationship. So that is the broadened definition that was inducted under the Domestic Violence Act of 2005. Along with it, the Criminal Procedure Code and 125 and the new code under the BNSS under 144 is giving the right to the parties to enter into maintenance or to seek maintenance if they are not having sufficient means and resources to maintain themselves. Now, if CRPC or the BNSS is giving a right and it allows a wife to move an application claiming maintenance since she's not having means and resources, then what about the woman in a live-in relationship? So by bringing this word domestic relationship, the judiciary interpreted, and it was also discussed by the Malamuth Committee and recommended that the woman in a live-in relationship must be brought within the fold of 125 CRPC. But however, till date, Criminal Procedure Code 125 CRPC has not been amended. Even the new BNSS does not contain the word the other woman. It is still the same provision as was existing under 125 CRPC. But the judiciary has been interpreting it to read the other woman, and she is entitled to move an application and claim maintenance if she is not having sufficient means and resources. And we are not going in for a very strict proof of seeking strict proof of marriage having taken place between the parties. Now, this Supreme Court has been analyzing these cases, and it is trying to ensure that the woman is not left as a destitute if she's not having means and resources, and it is trying to extend the benefits to this other woman through the Domestic Violence Act by reading 125 CRPC to her. Now, apart from the conceptualization of marriage, the fact is of providing legality to the children and the rights of such children who are born out of such relationship. Now, under the Hindu Marriage Act, if you look at section 16 and 18 of the Special Marriage Act, we say marriage legitimate children are have been given the confirmation of legitimacy. They are not treated as illegitimate children who are born out of such kind of marriages. However, the right to inherit of such children is limited with respect to the property. So a child will inherit the self-acquired property of his live-in parents, but he will not be entitled to the ancestral property or a share in the compassionary tree. That is, since the marriage is not in existence. Now, here again, there is one another issue when we say it is in the form of a common law or a customary marriage where parties have lived together over a reasonably long period of time. Under that circumstances, that live-in relationship is in the nature of a marriage. So would that child be entitled to claim his right to inheritance and succession and a right in the compassionary property? So that will vary from circumstance to circumstance, family to family, and the decision of the court will also vary depending on the facts and circumstances of the case. Now, if we read section 18 of the Adoption and Maintenance Act, it very specifically uses the word Hindu wife. So that means a woman in a live-in relationship with the man cannot move an application under section 18 of the Adoption and Maintenance Act to claim maintenance from her live-in partner if she was not married. So it is only a right accessible to a Hindu wife, and a live-in partner is not designated as a wife. She continues to be the other woman in relationship. So for that reason, is not entitled to the benefit under section 18. This was held in Ranjana Kejriwal versus Vinod Kejriwal by the Honorable Court of Law. Now, law always has a presumptive clause under 114 of the Indian Evidence Act. Now, it is raising a presumption or a reasonable belief that the thing is likely to happen or it is there in course of time, and we may presume the things to be in existence. So cohabitation over a long period of time gives us a reasonable presumption that the parties are in relationship, the parties are cohabiting together, they are living with under the intention that they are man and woman. So that presumption is acceptable, and the judiciary has been using this presumptive clause to ensure that the parties in a live-in relationship are not deprived of the right which they are entitled to. The Honorable Court in Badri Prasad versus the Deputy Director of Consolidation way back in 1978 held that live-in relationship between two consenting adults is legal if the requirement of marriage, like the legal age of the parties to enter into a marriage, or the parties have consented to I have consented to live together, and they are voluntarily cohabiting together. They are treat themselves to the rest of the society that they are man and woman, or they are the spouses of one another. So if this is the requirement, it is same as a customary form of marriage, and the court perceives that it could be treated that the parties are in relationship with one another. Then even in Payal Sharma versus Nari Niketan, the Honorable Supreme Court has affirmed that man and woman can live together even if they are willing, even without entering into a formal marriage with one another. There can be a demarcating difference between the conceptualization, because whether live-in relationship is morally justified, is it illegal? Is it in violation of the Hindu Marriage Act? Section 5 of the Hindu Marriage Act very clearly says a person should not have a living spouse. Now here, the spouse is not there, but is the person in an adulterous relationship, or he has been in relationship over a reasonably long period of time to confer the fact that it is constituting in the nature of a marriage. So there are conflicts which arise when demarcating the terminology between legal and illegal, moral and immoral. So if two individuals by choice are cohabiting together, they are believed to be in live-in relationship, and they are not to be treated as having committed a crime or a sin. In Indira Sharma versus B.K. Sharma, once again, the court specifically deliberated at length on the subject of live-in relationship, and it emphasized that there is a need for a basic framework to be evolved with respect to the living relationship. The definition under Section 2F of the Domestic Violence Act, no doubt, is ensuring that sanctity or approval can be given to a domestic relationship. But it is also emphasizing that the relationship in the nature of a marriage can include a number of aspects. 2 days, 2 weeks, 2 years may not be a time which says reasonably long period of time. So duration of the relationship must be such to justify this terminology. They must be living in the shared household, they must be pooling in their resources, or they must be financially managing their aspects. They have their domestic arrangements. Their cohabitation and relationship is in existence. They are willing to be happy in the company of one another. But the list can be very, very illustrative, and anything which is affecting the relationship can be added to it. So we cannot say that these are the 7 ingredients which constitute live-in relationship and nothing beyond that can be added. The court said that anything which is amounting to giving a relationship the cap of legality, that can be brought within the ambience of the terminology. The Honorable Court in D. Veluswamy versus P. Pataimal has emphasized that the relationship, when we say it is in the nature of a marriage, must be comparable to a institution of marriage. So that means that the couple are identified as man and woman. They are within the legal age of marriage. You cannot say both the parties are minors and they are in a living relationship. So they must be within the age of marriage, and they must be living together by free will and consent. They are within the qualified age to enter into a matrimonial union. So similarly, there is a consent, there is a willingness to live together over a reasonably long period of time. So same ingredient, if you date back to look at the common law, they are there, and traditionally people entering into unions without performance of ceremonies were following these essential ingredients. So we can also address that they are more or less like the common law marriages, but the formation and the format has changed with the change in times and circumstances. So Honorable Supreme Court has been analyzing these provisions to fit them either by providing them benefit under CRPC or by ensuring the benefits under Article 21 to the Constitution. Once again, the Supreme Court in Dhanulal versus Ghansham has emphasized that if a living partner is entitled with the right to inherit the property or not. Now, here again, right to a live-in partner to inherit the property will be dependent upon number of factors. Was the woman living with the man continuously, or she left over a short period of time? If she has been living with the person over a long period of time, for here it was for the last 20 years she was living with the person, though she never married that man, but this long cohabitation, the court held, entitled her with the right to inherit the property of a live-in husband. So it laid down the four-layered formula in this particular judgment. That person must be of a legal age to marry, must be qualified to enter into a legal marriage. They must hold themselves or represent themselves as husband and wife in the society, and they must have cohabited with voluntarily and willingly. Now, over a period of time, there have been number of transformations which are coming forward, which reflect the fact that live-in relationship are today becoming more and more common in the society. No doubt, marriages are also taking place at an equal pace, but still, the concept of live-in relationship today is not unheard of. Earlier, we used to believe that it is restricted to the metros. But today, even your own small city, you will find 5 houses away, a person is maintaining a living relationship. Now, the work culture, the shifting of the population, more people moving from their small cities to settle and earn a good money has vibrated this concept of live-in relationships, where people believe that it is more easy, more convenient, rather than to go into the hassles of a marriage. See, a live-in relationship, in contrast to marriage, is more convenient, more comfortable, because you are not chained by the laws. Getting into a marriage and getting out of a marriage contains a lot of complications, a huge tedious process, and then whether the other spouse is willing and consenting to go for a divorce. You want it is not mandatory that the other party will be willing and consenting to go for a divorce. But in case of a live-in relationship, it is more a convenient understand, a contractual union between the parties. They enter into an agreement, abide by the terms and conditions of the agreement. Things do not work out, you break out of that contract. So it is more comfortable rather than following the tedious process in the court of law, filing a divorce petition, seeking a maintenance application from the court of law, moving an application that you are being subjected to cruelty and harassment by the court of by the husband or the relatives of the husband. So things are very, very difficult. But similar issues have now emerged even in living relationship. Woman in a living relationship, when we say she's living over a long period of time, is moving an application under 498A, alleging that she is being subjected to cruelty by her live-in partner. Now, here is 498A, Indian Penal Code, accessible to this woman who is a live-in partner and not the legally wedded wife of the man? Can she approach the court of law to seek a relief for herself? Or 498A is not accessible to this woman? Now, traditionally, the court was of the opinion that since she is living, she is in a living relationship with the man, so she is entitled to the benefit and she should not be subjected to harassment by the husband. But the recent judgment of 2024, X versus the state of Kerala, the Kerala High Court has ruled that Section 498A cannot be made applicable to the partners in a live-in relationship. It has gone down to the root of the opening statement. If you look at 498A, it says cruelty by the husband or his relatives. Cruelty may be mental or physical. Now, here the first very word, cruelty by the husband or his relatives. Now, the court says that the word husband will come into picture only if the parties have entered into a legal marriage. Section 5 of the Hindu Marriage Act, essential ingredients must have been fulfilled. So here in a live-in relationship, the term husband is not there. We say the other man or the other woman, since the parties are not legally married. So since the word husband is non-existing, it is not feasible to initiate criminal proceedings against the husband or the petition under 498A of the Indian Penal Code. So they need to be, the husband has moved an application before the court alleging that since I am not the husband, I am the live-in partner. And 498A's definition excludes me. So I cannot be cast with the liability of going through this tedious criminal process. Therefore, there must be a quashment of the proceedings against me. So here the court has also held that 498A is not applicable to the person since he is not the legally wedded man. Now, this brings into focus the other aspect. Then when we say that living relationship is a relationship in the nature of a marriage, it must be cohabitation over a long period of time, similar to the customary marriage. Then again, there is a conflict between the two things, why we cannot designate him to be a husband when he has been a man for the last 20 years, and why 498A cannot be filed against him. But this is the perceptions that are now emerging with the growth and the movement of the society. So various high courts have their own vision. They are giving their own judgments. It will depend from situation to situation, circumstance to circumstances, and how the case is being presented and how it is being taken up. Now, Allahabad High Court was also rejected the plea of protection, which was application, which was made by the couples who were cohabiting together, alleging that since both the partners, they were already married, they were having their spouses, but they were leaving their spouses and both of them were maintaining a live-in relationship. The Allahabad High Court says that if the court gives a certification and a protection to all such type of relationships, then it will destroy the very social fabric of the society. It will create a chaos in the society. You move out of your marriage, you are not interested in the marriage, you like someone else. So it is giving a clear tag to the adulterous relationships which were, or extramarital affairs that were going on in the society, that you can move an application for seeking protection from the court of law, that we both want to live as man and woman. So for that, your status must be very, very clear. The similar framework that end the things earlier, and then you can seek another order from the court of law. But moving from one area to another just as an escape channel, because it is difficult to get out of a marriage, so you use live-in relationship as an escape chapter. So the High Court says this kind of a culture logic cannot be accepted in the society because this is threatening the existence of the order. Similarly, the Delhi High Court has allowed a woman in a live-in relationship the right to terminate her pregnancy, even though it was of 22 weeks, merely because her live-in partner had deserted her. So the court justified, concluding that it is the right of the woman to determine her bodily autonomy and her right to self-determination within the definition of Article 21, right to life and personal liberty. So she has a right to privacy, she has a right to self-determination, and she has a right to decide when, where, and how her body is to be used. So the court gave her the permission, interpreting the provision very liberally. The court has been emphasizing time and again that we are in for a prospective approach to ensure that we are not in for destroying the relationships, we are not in for threatening the institution. We are in for ensuring that if people want to cohabit or live together, or if they are in a situation where they believe that it is more appreciable or more preferable to live in a relationship rather than to enter into a legal marriage, then the discourse is available, options are available, and it is on the responsibility of the individual to determine. Now, another aspect we can look at it, can live-in relationship be identified as a contract under Section 23 of the Indian Contract Act? Now, if the court, with regard to say there is a consideration, an agreement has been entered into. Can an agreement for a consideration be treated as an immoral agreement, something as unlawful, to be treated as null and void? If a man alleges, take for example, that he had in the past cohabited with the person, cohabited with the woman, and he entered into an agreement at that point of time that he will share or transfer his property, or once he is no more, his property need to be transferred to his live-in partner. Now, the question is of, can such an agreement be made enforceable under the law of contract under Section 23? Now, here the court emphasized that it can be allowed, again, depending upon the length of the relationship. It is in the nature of a customary relationship, and whether that agreement is enforceable under Section 23 of the Contract Act. So if it is enforceable, the court can certify and grant the woman the right uh, uh, that the property can be transferred to her even after the death of the live-in partner. Similarly, the court has also been allowing, depending upon the agreements which have been entered into between the live-in partners, whether they can recover the arrears, whether the allowances that were promised to them during the cohabitation, they can avail those benefits. Again, it will depend from situation to situation as to what is the nature of the contractual agreement and how far that agreement can be enforced in the society. Now, the Patna High Court has emphasized that whenever there is a contract, it is, say, giving compensation to a woman for whatever she had lost on account of her past cohabitation. If she suffered certain losses because of the past cohabitation, and she can claim compensation because there was a contract entered into between the living partners at that point of time. And would that promise amount to a moral law, an immoral law, legality, illegality, and can it be made enforceable? Now, here the Honorable Patna High Court emphasized that since it was specified or entered and agreed to between the live-in partners that if anything such happens, women would have a right to claim compensation. So then such a contract can be enforced, but if it is amounting to an adulterous relationship, or if it was an adulterous relationship, then the contract would be null and void. So again, it will depend upon the situation and the circumstances. There cannot be a one clear defined line that it will always be, such a contract will always be legally enforceable. Even the Madhya Pradesh High Court has recognized the fact that past cohabitations, they are a good consideration. Even though there was no marriage in existence, the parties were in a living relationship. So the such contracts, they can be made enforceable. They can also be treated as lawful consideration, and whatever was agreed to, legal recognition can be given to the live-in partner judiciously without hampering the right of either of the parties. So there can be a valid contract which can be made enforceable, subject to the condition that the parties were in a live-in relationship over a reasonably long period of time. Now, added to that, just lately, the Uttarakhand High Court, rather the Uttarakhand government, I would say, has proceeded to evolve the Uttarakhand Uniform Civil Code, whereby they are emphasizing that it would allow protection to interfaith couples under the condition that they will register under the Uttarakhand Uniform Civil Law, Civil Code, and it must be done within a period of 48 hours. So the UCC of Uttarakhand contains a provision which is clearly specifying that if the partners, they are intending to reside in the state of Uttarakhand, or they are not even the residents but are there in Uttarakhand, and they are living together, then they are under a binding obligation that they will move an statement under section 381 of the Uttarakhand UCC to the registrar, emphasizing that they are there within his jurisdiction, they are living, and they should be, that they are living and they are in a living relationship. Then it will be the responsibility of the registrar to ensure that he will provide protection to them. Their right would not be hampered, and there would be no threat to their lives. So during that period of time. So this effort is a process towards giving a legal coverage or a recognition to live-in relationship in the society. So, but at the same time, whether a married man and an unmarried woman are in living, and can that be designated as a live-in relationship in the nature of a marriage, giving the right to the parties. Now, here the Madras High Court refused to recognize their relationship as live-in relationship. It emphasized that the live-in partner, one being married, is having a wife, having children, having the responsibilities, and the other woman is a single woman. So here, conferring the right or giving them the legal protection to live in a relationship would hamper the growth of the society. So such a live-in partner is debarred from moving an application for seeking maintenance, seeking the right to succession of the live-in partner subsequently, or even the right to inherit his property. So idea is, if you analyze the entire concept of live-in relationship, we are not in for breaking the framework of the society. We are only trying to evolve an alternative where people are restraining themselves from entering into matrimonial union. They are more in for a living relationship, either because it suits their concept, either because it suits their work life or the working culture which they are now accustomed to under the changed situations and circumstances. So here the idea is that People have a right to life, they have a right to privacy, they have a right to enjoy their life as per their needs and necessities. So just by giving a nice coverage or just by saying yes to everything, law cannot be appreciating or condemning the wrongs of the society. So we are here to ensure that all legal goods or trying to be very good does not amount to destroying the very purpose of the legal provision. It should not be encouraging the harassment either of the male or the woman. Then 498A is cruelty. There can be another aspect, demand for dowry. If it is existing in marriage, it can also be there within the live-in relationship. Now here again, dowry is being demanded. So that means there is a lust for money. So demand can come from either side. And if a live-in partner is demanding dowry, it means he's shifting or shirking from his responsibility. What is the liability of a woman? Just because they are in live-in, is she under a binding obligation? Since they are not married, she may walk out or the man may walk off. But the question is that law need to strike again a balance that if we say it is not cruelty or it is cruelty, demand for dowry should also be brought within the fold, and dowry cannot be demanded because it is a consensus agreement between the two parties. If there is a demand, the other party has a right to move out. But the same does not stand true in a matrimonial union. So if we are giving the coverage, it is a relationship over a long period of time, then there is a need to understand this aspect, that relationship, whether it is marriage or whether it is a live-in relationship between the parties, there is a need that greed should not be emerging between either live-in relationships or in marriage. So if we can put a check or a restriction, or the law can be coordinated, channelized to ensure that these wrongs can be checked or restricted, then the relationship can move on a more faster or on a smoother phase within the framework of the society. Now, apart from this, if we analyze the fact that live-in relationships today are becoming more and more increased is primarily because waste their time and energy. The Patna High Court has emphasized that if there is a contract between the live-in partners and the contract contains a clause that a woman need to be compensated for the loss she would suffer on account of any past cohabitation subsequently, then it is the responsibility that the contract need to be enforced under the law, and the contract being enforceable, the party woman would be entitled to claim compensation. But it depends upon the nature of the contract and the terms and conditions which were entered into between the living partners. If a contract is not enforceable, if a contract by its very nature and content is void, then it cannot be enforced in the society. Then the fact that if the woman is being subjected to harassment, demand for dowry was made from a woman, and demand itself, if we say dowry, usually is equated with marriage. So there was a demand for dowry. Either it was in relation to marriage, it was before marriage, it was during the conversation for finalization in relation to marriage is existing. Now, whether there can be dowry in case of live-in relationship. Now here, if there is a demand from either party for dowry and it is amounting to harassment of the woman, then it is the right of the party to walk out of the relationship. Since it is a live-in relationship, there is no process where she need to be subjected to cruelty or harassment or need to fulfill the demand for dowry which is being made. But at the same time, if the live-in relationship is calculated as a relationship over a long period of time where the parties have been cohabiting together, still the man or the female, whosoever is making such an unreasonable demand, cannot shirk their responsibility or their liability merely because of the fact that they are in a live-in relationship and merely because demand is not being fulfilled. They can get out of that marriage. So there is a need to strike a balance between long cohabitation in the nature of a marriage, living relationship, and the institution of marriage, which we constitute as a sacrosanct union. So cohabitation, past cohabitation, and the agreement entered into, the contract, if it is enforceable in law, they are authorizing and providing a legal recognition to a person to claim the loss or compensation for whatever loss the person has suffered, whatever harassment the person has suffered at the hands of the other party. Now, the live-in relationship, no doubt, have today gained a momentum in the society, and they are preferred in the society. And but at the same time, if we look at that, most of the people in live-in relationships are also entering into marriage. Why they do not continue only in live-in relationship? Why they want the union to be given the legal liability, and they are entering into and performing the essential requirements under Section 5 of the Hindu Marriage Act. So that itself speaks volumes of the fact that the institution of marriage has not lost its significance. Marriage still continues to be the end conclusion, because that is the institution which is conferring you with the legality, with the right to maintenance, right to succession, right to inheritance, right to legitimacy of the children, right to determine that you are the son or so and so. Whereas, okay, therefore, it is very necessary assumption in favor of the marriage law is, but still law prefers that there should be habitation over a long period of time. Now, how much period of time? There is no use the terminology that it should be over an unreasonably long period of time that the persons have been living together and cohabiting together, and it must be a continuous relationship. That is very necessary. It does not mean that you live for 2 years and then you walk off, and then you again come back for another 3 years and again you walk off. So it is a continuous relationship with and cohabitation which brings the living relationship into significance, to draw a reasonable presumption that the parties are living together and they are known and understood together to be as man and woman. Now, having analyzed the judicial aspect, the law which we are currently having on hand, the legality which is required, the society addresses the question of viewing live-in relationship as, are they a better alternative? That is an open question to the society at large, that do everyone prospectively look at the thing and view that these relationships are to be accepted as an alternative to the institution of marriage? Or we would say that live-in relationship will give both man and the woman a reasonable investment and security of relationship, or it is only a temporary phase before the parties arrive at a conclusion that they will enter into a matrimonial union and they will enter into a marriage as per the essential requirements of Section 5 of the Hindu Marriage Act. Or we can provide legal sanctity, just as we have given to marriage, to the live-in relationship, if we provide legal sanctity to live-in relationship, is there a like, so this is again a prospective question, I may be wrong in my opinion, that is giving such legal sanctity to live-in relationship and treating them as at par with the marriage would encourage bigamy, adultery in the society, amounting to threatening the legally wedded woman. What is the advantage which a legally wedded woman is having in contrast to a woman in a living relationship? Normally, a woman would say, if my husband is going around with somebody, never mind, he will come back because I am in the house. I have a right to the house. I have a right to shelter. I have a right to maintenance. I have a protection order which I can take under the Domestic Violence Act. I can take a monetary relief. I can take a custodial order. Now, all these benefits are coming to her because she is the legally wedded wife of the man. Then she is entitled to the succession tree. She has a right to inherit. Her children has a right to inherit. All these are not accessible to a woman in a live-in relationship. There are so many ifs and buts, pros and cons. So how do we come down to a conclusion that a woman in a living relationship can be treated as on a same footing at an equal platform to a legally wedded wife? Children. Which children are legitimate? We are conferring the title of legitimacy. We are not saying they are legitimate. Law is conferring the title of legitimacy because the child is not at fault. Act done by the parents, why should the child suffer? Why we should demarcate a child? But we often hear things from the society that the parents are not there, the parents are not married, you do not know whose son or daughter the child is. So these kind of relationship, the social compatibility, the social appreciation of this relationship, and absence of the institution of marriage. So how far it is prospective or how far it is threatening the social framework of the society, and who would be taking the responsibility? Say the live-in partners is having a child. Both the partners move their own way, leaving the child. Who will take care of the child? The mother walks away, the father walks away. Where will the child go? To an orphan home? Why are we bringing such children into the society when no one is responsibly to taking the responsibility to of such children born out of such live-in relationship? You are in a live-in relationship for 10 years, but tomorrow your family disagrees. You come back from your workplace, you marry a place where your parents want to. What about that child whom you have given birth to? Similar may be the situation of the mother who may walk her own way. So what kind of a society we are trying to produce? Is it because for our own convenience, your own liking? Why are the children being subjected to this kind of a social disintegrated environment and for no fault of theirs? So would this amount to bringing more parentless children in the society tomorrow? And whose legitimacy itself will also be a big question mark. We may not know who is the child of who. Now, if such practices are continuing in the society, is it providing an open ground for prostitution? Is it giving an open stage for the onset of this kind of crime or offense in the society? Would it lead to psychological frustration? Would it amount to exploitation, both mental and physical, of the children? Would such children or would such partners in live-in relationships would be able to maintain the same compatibility, the same relationship with the other person whom they are subsequently likely to marry? Or they would be more frustrated, they would be psychologically imbalanced. So these are the core issues which emerge out of this debate on live-in relationships. That on the surface, it may appear to be very good. Your choice, enter into a matrimonial union or live in relationship. But there is always a dividing line which says that this is within the domain of law. This is something which we are indirectly stretching, interpreting to bring it within the domain of law, since the law is capacitated to provide you, since we are alleging that I have a right to life, I have right to privacy, I have a right to decide and determine my likes and my dislikes. So all these preferences are somewhere or the other bringing in a threat to the social framework of the society. So whether we are financially independent, we are socially secure, we are morally working on a logical conclusion, the focus is to understand that live-in relationship, if they are being governed in the society, still it is a check on each individual to identify, to recognize, and to understand that the limits need to be imposed, they need to be clarified, they need to be demarcated, so that the society tomorrow is not suffering from the complications, or it is not suffering from the blocks which may be working as constraints in the growth of the society. Thank you so much.
Oh, ma'am, in the chat box, there's a question. What are the provisions relating to live-in relationships where one of the party is a minor?
Live-in relationship, since we say that there is a necessity that the party must be in a capacity to enter into a marriage. So the live-in relationship is not being read with respect to the minor. They must have a capacity to marry,
Okay.
right? Legal age of marriage is very, very mandatory for a live-in relationship. If you qualify for that, you must be having a capacity to enter into a legal marriage, so you can be identified as man and woman.
Good afternoon, madam.
Good afternoon, sir.
Madam, it was really very nice session. I am from Uttarakhand, and here the government has drafted one uniform civil code, and
Yes,
I would
yes.
just like to add that there is one separate entire part 4 is
Hanji.
devoted to this live-in relationship. So they are going to be legalized, but registration will be compulsory. And I have not yet gone through all the provisions, but there are a few say last sections are there,
Hanji.
and they are available on the internet. So if the government implements this uniform civil code over the entire country, then the registration will be compulsory for these live-in relationships also all over India. Thank you.
Yes, sir. That is a very good perspective if they try to make it a condition for that. But registration becomes very, very difficult, sir, since we are not in for compulsory registration. Here we say marriage registration must be done compulsorily, but only when people are boarding the plane, they know that they need to get their marriage registered. Otherwise, no one is bothered to go for registration.
Yes, and there was some criticism that why government is invading our privacy, what right they have to say
Yeah,
look into our
right.
bedroom. But if the child comes out of wedlock, then say it is the responsibility of the society, and that's why the law for live-in relationships should also be there. Thank you.
Definitely, sir. The problem is not with the couples who are living together. The problem is with the children who are likely to be born out of such relationships.
Yes, yes,
That
because
is
they
a
will be
major issue.
yes, yes, because that they will be part of society, and that's why it is not just matter related to privacy or bedrooms only.
Yes, yes. That is the reason why the more focus is on that, why everyone is in favoring for live-in relationships in contrast to the institution of marriage.
Yes, thank you, madam. Thank you so much.
Thank you. Thank you, sir.
Ma'am, the next question is it okay if the government documents do not have the name of the father?
Yes. Nowadays, there is an option. We can use the name either of the mother or of the father. Even on the Aadhaar card, you have a right. You can use the name of your mother or you can use the name of your father. We're no longer going with that the name of the father is mandatory.
Any more questions, participants? Ma'am, there's one more question.
Right.
Can a complaint be instituted against a landlord who doesn't want to enter into an agreement with a live-in couple?
See, that can be that will have nothing to do with the living relationship. It is the right of a landlord to give you an accommodation or not, merely because you are in a live-in relationship. the landlord is not usually refusing. It is only if he has a likely belief that you are indulging into an adulterous act or it is prostitution. That is a major threat, because it is very difficult to demarcate whether the woman is a legally wedded wife, the woman is in a live-in relationship with the man, it is an adulterous relationship, or it is a one-night stand, prostitution is going on. So
Okay, ma'am.
otherwise, it is the pure discretion of the landlord.
Ma'am, the next question. We all know that marriages of same-sex couple are void in India. So, what are the provisions to protect the rights of same-sex couples?
See, today marriages are between the same sex is not void. You are getting a right. You move an application to the High Court, same-sex marriages are recognized and the party is entitled to marry. The next problem, which is complicating, is about the children. Is about the children. What they are claiming is the right of to have a child. Now, giving a right to have a child to the same-sex couple has elaborated another debate. That is, since surrogacy has been banned in India. So that has created a problem that how would a same-sex couple bring a child? Then there are a lot of questions and checks on the infertility clinics which are going on. Earlier the custom was anyone to anyone could be going on. Now the check is very, very strong. Everything is being demarcated to understand that whether they are going in for an illegal practice or there is actually a need and a demand for that. So looking at that, picking up anyone and posing him as a man just because you want a child and just because you want a male child. So they have created those kind of now barriers to ensure that these practices are not going on out and just like that. But if the same-sex couple is entering into a marriage, they can enter into a marriage. Now, after Navteej Singh Johar, they are having a right to marry. You move an application, you are entitled to the right will be awarded to you for you can enter into a marriage. We have number of people in Jalandhar who have entered into same-sex marriages. Two girls in Amritsar, just I think 3 months back, entered into a marriage. Question is not of the marriage. Question is the consequences of that marriage. Would the child, if you are having getting a child through surrogacy or you are adopting a child, there is no provision under CARA which gives the same-sex couple the right to adopt a child. So we need to look at the law, which is now under the scanner, that once you are giving a right to marriage, you are opening the Pandora box. And how are those other rights to be fulfilled? How are they to be granted? Where the checks and balances are required.
Okay, ma'am. Ma'am, I think last question. In the span of your research, madam, did you come across any observations of the court where you felt that judges have a bias in the matters relating to live-in relationships?
Actually, what I feel is that judges are not biased. They are rather in for or favoring the live-in relationships. Number of time the applications which are coming up for live-in relationships, protection orders are given by the High Court whenever the couples allege that they are under a threat from their family. Intercaste marriages, interfaith marriages. High courts are liberally granting the protection orders to such kind of couples because just they want to live together and the family is not interested. Even if the every time the application is coming forward from the live-in partner, either to claim compensation, either that they have a right to cohabit and their right is being restricted by their family or their rights are being denied to them, the courts have been interpreting the live-in relationship provision very liberally. In contrast to the traditional ideology that the judiciary would be more strict, rather judiciary is more liberal in respect to live-in relationship. And that is also looked upon by the society that is the judiciary giving a leverage and threatening the institution of marriage. Because wo in out and in and exit chapter is very, very convenient. So they feel that why should you marry?
Mhm.
But still, you see, people in live-in relationship are also getting married. So that means the institution has a value.
Yes, ma'am.
Yeah,
It's ma'am also because of the parental pressure and
yeah, that is also there.
yeah.
But see, most of the people, like I belong to Punjab, and we fall in the Doaba belt. And here, I think every second family has left the country and they are all settled abroad. So the problem here is that people do not know what is going on. Only the older generation is left. So the young people have all moved out and they prefer to be in live-in relationship rather than to take on the compulsion and the compulsions of the marriage. Who will take the responsibility? They feel enough money is not there to fulfill their needs and necessities. So they still have one hand at the back that what the father can send them, or they will call their father only when they feel there is a need to have a child and who will take care of the child. So because of these scenario which has changed all over and basically the thinking of the generation, everyone is living for their own self. Society, family, that has become very, very marginalized. So because of that also, majority of the younger generation today prefers to be in a live-in relationship. They will marry only when the pressure is coming down from the family. Otherwise, they prefer to live like that. Yeah.
Totally, ma'am. So, ma'am, we are done with the questions. Okay. Thank you so much, ma'am, for such an illuminating webinar and giving us so many valuable insights today. Thank you.
Thank you so much, ma'am. It was a pleasure.
Same here, ma'am. Thank you, ma'am.